Hello, everybody. It's Roger Royce. I'm a partner with Haynes Boone in Palo Alto and also the host of the 10,000 Startups podcast, Legal Strategies for Startup Success. Just a quick one. We've got a podcast coming up on the new Federal Trade Commission FTC rule banning non-competes for workers. But I want to give you the 2-minute update here, and you can listen to the more extended podcast in a few days when it gets released. But as you probably have heard, about a week ago, the FTC released its final rules banning pretty much all non-competes for workers. There's a few exceptions. And you may recall about a year ago, early last year, the FTC proposed rules that would ban non-competes on the basis that they are basically unfair competition and an unfair method of competition under Section 5 of the FTC Act, rather. And those proposed rules got something like 26,000 comments, but they've gone final. We now have a final rule. They'll become effective, assuming nothing changes, 4 months after publication, which would be in September of this year. But a lot could happen between now and September. 3 lawsuits have been filed trying to enjoin the enforcement of these rules already or declaring them invalid. But in the meantime, I think we have to prepare for them as if they are going to go final. I'll be talking a lot more about this in my podcast, but keep in mind, it's a 570-page rule. So it's going to take me a little while to get through it, condense it, digest it, put it into a 20 or 30-minute podcast. In the meantime, here's the 2-minute version. Like I say, it effectively bans all non-competes for workers. That's employees, independent contractors, etc. And what it considers to be unfair competition are really 3 things. It's to enter into or attempt to enter into a non-compete with a worker, to enforce or attempt to enforce a non-compete clause, or finally to represent to the worker that they're subject to a non-compete. Now, here in California, I haven't worried too much about that because we've had rules against non-competes for employees forever, for a long time, and we're used to it. And we're used to all of the questions that are probably coming up in everybody's mind and all the sneaky ways people think they're going to get around this. We've been through all that. And these rules took the benefit of that experience, and they go on and on about some of these things. First of all, what is a non-compete? It's any term or condition of employment that prohibits a worker or penalizes a worker or somehow prevents a worker from accepting work after their employment or operating a business after their employment. So that's all it has to be a non-compete. So it's super broad, and it could cover things like you forfeit your severance, you have to pay us if you compete. It could be hidden in a non-disclosure agreement, could be hidden in a non-solicitation agreement. In California, we see that happen all the time. And, we've dealt with it here, so we've got the benefit of that experience. Now, there are a couple of exceptions. Bona fide sale of a business exception. We have a similar exception in California. That's a non-compete in connection with the sale of the goodwill of a business. So very similar. There's an exception for a cause of action that concerning a non-compete that accrued prior to the effective date, and another exception based on good faith basis to believe that this ban is not applicable. Probably the biggest exception that you've heard about is that the rule is going to be retroactive except for non-competes agreed by senior executives prior to the effective date of the rule. Now, another interesting thing about this is that there's a notice requirement in the rule, and employers have to send a clear and conspicuous notice to all of its employees who have a non-compete that their non-compete clause cannot be legally enforced against the worker. We have a similar rule in California as of this year anyway. Fortunately, the rule gives you a sample notice with some magic language, so you don't have to guess as to what it takes to satisfy that requirement. So what do you want to do now? Well, probably a good idea if you have employees in other states. Definitely need to really take a look at your handbooks, your employment contracts, your contractor agreements, your NDAs, your non-solicitation agreements, all that stuff, and just be prepared You got till September, and a lot could happen between now and then. But probably best to be, ready to go on this and ready to post the notices when you need to. And then the other thing to do is, I know everybody's going to have a million questions as to, well, gee, how do we protect ourselves as employers? And again, we have the California experience where we basically rely pretty heavily on trade secret protection and confidentiality clauses. But keep in mind, they can't effectively function as a non-compete. So you want to hear more about this, make sure you tune in to either the YouTube video or the 10,000 Startups podcast on all major podcast players when we take a deeper dive into the FTC rule on non-competes. This is Roger Royce, host of the 10,000 Startups podcast.